May it please the court, in the Court of Appeal in Sabah, holden at Putrajaya via video conferencing on 15th of June 2020, the panel of judges are the Honorable Datuk Abdul Karim bin Abdul Jalil as the chairman, the Honorable Datuk Norbi binti Arifin, the Honorable Tuan Ravindran, son of Paramaguru. Number 1 from the list of appeal, case number S04A37107-2018, Ibrahim bin Abdul Manap for the appellant, Messrs. WV Partners, Benta Wawasan Sdn for the respondent, Mrs. Amin Jaafar and Co. May it please my lords and my lady.
Yes.
May it please your lordship.
Yes.
I'm Connie Wong, together with Ms. Liu Mei, appearing for the appellant in this matter, and my learned friend, Mr. Mark Rosaide, appearing for the respondent in this matter.
That is correct, my lord.
My lord, today is fixed for 2 hearings, namely the hearing for preliminary objection raised by the respondent, together with the hearing of an appeal to set aside the certiorari order granted by the High Court judge on 6 June 2018.
Yeah. Yes.
My lord, may I respectfully start with the preliminary objection or respondent?
Mr. Mark, is it? Mr. Mark?
That is correct, my lord.
Yes.
I am for the respondent.
Yes. Yes, proceed, please.
My lords, my lady, we have given our intention to raise this preliminary objection to the counsel for the appellant via our letter dated 9 of June 2020. I am sharing the letter now. The letter is also filed in court and marked as enclosure number 28. This is the said letter. My lord, we have also filed a short submission in respect of this preliminary objection. My lord, this preliminary objection is premised on the fact that the notice of appeal was filed outside of the time limited required under the law. Now, the High Court judgment in this matter was delivered on 6th of June 2018, and the notice of appeal was filed on the 26th of June 2018, well within the time stipulated under the law. However, the notice of appeal was only served on us on 16th of July 2018. I now share the
How many days delay? How many days?
About 2 weeks, my lord. 10 days to be exact. I now share the covering letter enclosing the seal notice of appeal. This is the letter, my lord. As your lordship can clearly see, the letter is dated 13 July.
Which letter? Which
letter? Must be filed and served within 30 days from the date of judgment. This is provided under Rule 6 of the Rules of the Court of Appeal, read together with Rule 12 of the Rules of the Court of Appeal.
Where's the letter? Where's the letter? Which letter are you referring to?
This is the letter.
Which one? Not
This is the
one.
letter that enclosing
No, letter dated.
the letter raising preliminary objection.
No,
No.
letter dated 13 of July.
The one dated 13th of July.
Yes, this is the letter, my lord.
Wait.
You cannot see that.
You can see that.
It's the previous.
I've already shared the.
Can you stop sharing the chat?
Yes, this is the letter. Can your lordships and your ladyship see the letter?
16th of July.
16th of July 2018, which is about 10 days after the expiry of the time limited for them to file and serve the notice of appeal. Yeah, I carry on, my lord.
Yeah, please proceed.
Now, my lord,
If you can respond directly on the issue raised by the appellant counsel. Please refer to the first part of the letter just now. Refer to the letter just now. The first part. The paragraph 1 of the letter. You refer
yes, my
there
lord.
because it was stated there. We refer to the above matter and the email sent by Ms. Ho will lead to your good office on 29 June 2018. And now, appellant counsel is saying that amount to good service for purposes of service of the notice of appeal to the respondent. So can you reply directly, addresses on this point?
Yes, my lord. I respectfully submit that the act of the court in sending the email enclosing the notice of appeal is only an administrative action on the part of the court. It does not amount to service as envisaged under Rule 6 of the Rules of the Court of Appeal. Because we are saying that the court is not a party to the proceeding. It is only logical, since the appellant has the duty to file the notice of appeal, it is only logical for them to have the same duty to serve the said notice of appeal on the respondent or any other parties affected by such decision. My lord, though Rule 6 does not clearly state who has the burden to serve the notice of appeal, but we stand by our argument that the burden rests on the appellant throughout. To support our proposition herein, and as a matter of analogy, I wish to respectfully refer your lordship to Order 55, Rule, before that, my lord. Now, Rule 30 of the rules of the Court of Appeal stipulates that as a matter of, in relation to service, the rules of court 2012 shall apply mutatis mutandis to the rules of the Court of Appeal. Now, that being said, I wish to draw your lordship's and your ladyship's attention to Order 55, Rule 3 sub 4 of the rules of the Court of Rules of Court 2012. I now share the. In fact, I've prepared a short submission on this. I share the relevant part. Yeah. Share screen. Okay, sorry. One moment, my lord. Yes, yeah. Now, Order 55, Rule 4, Rule 3, Sub 4 of the Rules of Court states this one. A duplicate copy of the notice of appeal must be served by the appellant within the time limited for the filing of an appeal on all respondent. Now, this provision shall also apply by virtue of Rule 30 of the Rules of the Court of Appeal to the current case, to the present case before your lordship and your ladyship. Now, it is illogical to say that just because the court has forwarded an email enclosing the notice of appeal, it serves as a service on behalf of the appellant. That cannot be the case in this situation, my lord. Otherwise, it will set a very bad precedent for future cases whereby counsel will argue that the duty lies with the court to serve such notice of appeal, just because Rule 6 is not that specific on this matter. Now, as a matter of analogy again and reference, since this matter is filed in Sabah and Sarawak, as far as the e-filing system in Sabah and Sarawak is concerned, for example, if a defendant's solicitor file a statement of defense, as a matter of course, the court system will then send a notification to the plaintiff's solicitor in the form of an email informing that a statement of defense has been filed. And in some instances, the plaintiff's solicitors will be able to have access to the statement of defense. But the defendant's solicitor will still, in practice, still serve the actual statement of defense just to comply with the law. If we were to apply this, the argument of the appellant in this matter, then by filing the statement of defense in the system, and then the court will send a notification amounts to service, this will create uncertainty under the law. Our stand is this: since it is the appellant that has the duty to file the notice of appeal, the same duty must be cast upon them to serve the notice of appeal. The administration act of the court cannot be confused and be deemed as service on behalf of the appellant. That is our short reply on this issue. And furthermore, my lord, if we were to refer to the letter, one moment, my lord. Yeah, this is the letter. This is the letter now. If we were to read the letter carefully, the appellant submitted that this is a second reminder, which is, we respectfully submit this is an afterthought argument. If we were to read the letter carefully, of service or as solicitor, it is not as a matter of reminder. In fact, in law, there is no requirement for the appellant to give such reminder. Once service has been done, then that's it. They realize their mistake, and then thereafter they have sent this letter to cover up their mistakes on this part.
What is the purpose of the service?
It's to bring the yes, my lord, it is to bring the attention of the parties to the appeal.
So once by receiving the email from the court, are you not notified of the pending of the filing of the notice of appeal by the appellant? Are you not notified?
Yes, we were notified, but that is not the law, my lord. The law is very clear. They need to serve the court. They themselves need to serve the notice of appeal on us. Otherwise, this will be haywire. Like I've said, like I've submitted earlier, then the burden will be on the court to serve such letter. Such a document, sorry. There must be certainty in the law, my lord.
Well, when is appeal considered to be to have commenced or filed? When an appeal is commenced?
On the day immediately
when the notice of appeal is filed, or not? When the notice of appeal is filed,
yes,
that is when the appeal is said to have commenced, or not?
My lord, with due respect, the case law seems to suggest otherwise. appeal is only brought forward and when the notice of appeal is filed and served. This is clearly stated in the federal.
The two components will be there. The two components,
Sorry?
the two components, filing and service. That's what you're saying.
I've in fact, yes, in fact, I've referred this one federal court case on this matter and two federal appeal case on this issue as well. Filing without the service does not amount to bringing forward the appeals. That has been the law.
Yeah.
I have to ask him some question.
Nothing further.
Mr. Mark, I have 2 or 3 questions on what you said about the system. Okay. Your position is that the email through the interpreter is not, through the interpreter who sent an email, like a Gmail, I think is not service. Then you also say that in the court management system in Sabah, I think it's popularly known as CMS, that whenever somebody files a document, a course paper, like an appeal or statement of claim or rate, one copy is sent to the defendant. Correct? That's what you said. But still, as a matter of practice, they still serve the hard copy on the defendant lawyer. You did say that just now, correct?
That is correct, my lord.
Oh, good. So in this case, when the notice of appeal was filed on the 11th of, I'm sorry, the date, which was when the notice of appeal was filed, I know it was served late, as you say. One copy would have come to your office through the court management system, the case management system, the CMS. Am I right or not?
That is correct, my lord.
So I want an answer from you, a definitive answer, because we can go to the court system, we can ask the court officer to inquire and investigate this. When your learned friends filed the notice of appeal, did you or did you not get the notification that there is an appeal file?
Yes, we did receive an email on that notification.
Okay, one moment, we will record the answer down. So as soon as they filed the appeal, you got the notification. Now I'm asking this question not to investigate what you got or you did not get. I'm asking this question because your learned friend, in one portion of her submission, mentioned that this may come under Order 62 Rule 11. If a notification or notice go through the court system, you have to read the whole of Order 62 Rule 11 because it's a long rule. It says that anything sent which a registered user receive is valid. You must read the whole thing.
Yes. Now, in the
notification was sent. Can you not see the notice of appeal when you go and click on the button? You can see the notice of appeal as well. Can you not see?
Depending whether they allow us to view the notice of appeal or not. In this case, I can't really remember because it was 2 years ago, my lord.
No, but the notification was sent to you saying there's an appeal. Once you get a notice of appeal, can you not see, sorry, a notification about the appeal, can you not see the notice of appeal?
The actual notice of appeal, it depends whether the party allow us viewing or not. If not, we can only see the notification.
Yeah. Okay, but if you can see the notice of appeal, my narrow question is, can this fall within Order 62 Rule 11? I'm sure you're familiar with Order 62 Rule 11 because your learned friend has reproduced this in a submission. Will it fall under Order 62 Rule 11? Please answer my question.
As far as the notice on the notification, yes.
No, if you can view the notice of appeal, will it not fall under Order 62 Rule 11?
Yes, my lord.
You must understand, I have some familiarity with the Sabah case management system, you know?
Yes.
So you are saying they did not let you view the notice, is it? Is that what you're saying?
No. I'm not saying that.
There's an appeal. Immediately, within the time limited, you had notification right from the system that there's an appeal. Did you not? You said yes just now. We recorded that. Yes. Now you're saying you don't know whether you can view the appeal or not. So, all right, I think that's the question that I wanted to ask you.
Just to clarify on that matter, we actually received the notification, but I can't really remember whether we are allowed to view the notice of appeal or not. That is my answer to your lordship's query.
We don't know whether you can view, and if you can view, assuming if you can view, then the rule is not breached. Is that what you're saying?
Yes.
Notice of appeal. That means you're also saying the rule is not breached. Not the what you call the fact that they send the hard copy outside the time limited. That rule is not breached if you can see. Is that what you're saying?
Sorry, Manap.
If you can view the notice of appeal once you got the notification, you mean to say that the rule is not breached? Is that what you're saying?
No. My argument is that the rule.
You know whether you can view the notice or not. If you get notification, you click, you cannot see the notice. You should know. Oh, there's a notification of appeal. I cannot see the notice of appeal. You should remember this one. Are you just saying you know there's a notification, but you don't bother whether you can see the appeal or not?
Yes, but on the point of Order 55, my lord, did you still like
Order 55? We need to read all the rules here. Order 62, Rule 11 is to address electronic notifications of documents. So I'm asking you whether you got notification. You said yes. But when I ask you, can you see the notice of appeal? You cannot remember. But you take the position the rule is breached. I understand your earlier argument. Interpreter sending the notice of appeal by email is not provided in any rule here. You cannot put this type of burden on interpreters. But through the CMS, the court management, the case management system is a different matter. So, okay, I'll just record your answer. You have agreed that you got the notification, but you don't know whether you can see the notice of appeal.
Correct, my lord.
Yeah. Yeah, correct. Only. Yeah, Miss Correct, reply please. Yeah. Yes, reply from the appellant.
May I start with the submission with the purpose of serving the notice of appeal? This is well stated in the case of Court of Appeal case, Redang Paradise Vacation Sdn Berhad. Against Yap Chuan Bin. My lord, we'll be doing the screen sharing now.
What's your point, please? Go direct to your point.
In this particular Court of Appeal case, it was held that the whole purpose of serving a copy of the notice of appeal on the opponent or the respondent is to give early notice to the parties that the appellant is dissatisfied with the decision of the court and that he wishes to appeal to the High Court. By this early notice, there will be no room for surprises, delay, and prejudice caused to any party directly affected by this appeal. By receiving the email on 26 June 2018, the respondent is deemed to have notice of the appeal that the appellant is intending to do. There is no room for surprises, delay, or any prejudice caused to the respondent in this matter. Furthermore, we would like to refer my lord to Rule 3A of the Court of Appeal Rules. Rule 3A of Court of Appeal Rules is about the preliminary objection on the ground of non-compliance. In this preliminary objection application, the appellant has not caused any non-compliance of the rules. A court or judge shall not allow any preliminary objection by any party only on the ground of non-compliance of any of these rules, unless the court or judge is of the opinion that such non-compliance has occasioned a substantial miscarriage of justice. Therefore, in our case, by receiving the first notice of appeal from the High Court interpreter, the respondent has already gotten the notice, the necessary notice. We would like to refer my lord to another rule under Court of Appeal 1994 as well. This is about the non-compliance of any of this rule. Under Rule 102, it says that non-compliance with any of this rule shall not render any proceeding void unless the court or judge shall so direct. But such proceeding may be set aside either wholly or in part or amended or otherwise dealt with in such manner or upon such term as the court or judge shall think fit.
Are you admitting that there was non-compliant? Are you admitting that?
No, my lord. As just now, which was mentioned earlier, the appellant maintained no non-compliance with the rules, meaning the appellant has complied fully with the rules.
But if you have complied with the rule, then there is no necessity to refer to these rules, right? Not?
My apology, my lord. Yeah,
So
I was saying.
you are saying that the law requires the service to be done by the party, right? Not the court. But you are saying in this case, the service is good amount of good service because it has been done by court as your agent?
Yes, my lord. Because the Rule 6 regarding the service of the notice of appeal itself did not specifically mention as to who should do the service, so long as the respondent has gotten notice within the time limited for the notice of appeal.
Sorry. Ms. Connie, what about Rule 55, Order 55, Rule 3? The one that was referred to earlier by Mr. Manap. What about the effect of that particular provision?
My lady, with respect to Order 53, Rule 3, this is applicable to appeals to High Court from subordinate courts. In fact, the rules that apply to our current appeal should be the Rules of Court of Appeal 1994.
Mr. Mark was saying that it was by way of analogy, that it bears the burden is on the appellant to serve a copy of the notice of appeal on the respondent. By way of analogy, Mr. Mark, you were saying just now?
That is correct, my lady.
Because you were saying that nowhere in the rule says who bears the burden of service. So Mr. Mark draw an analogy from that particular provision to say that it bears, the burden is on the appellant because appellant is the one, the law require appellant to, the service of the filing of the notice of appeal is on the appellant. So the duty to serve equally rests on the appellant. Is that correct?
That is correct, my lady. That is correct, my lady.
So how do you respond to that, Ms. Connie?
My lady, we do not agree. As mentioned earlier, we refer to the Rules of Court of Appeal, Rule 4, which says that where no other provision is made by any written law or by this rule, the procedure and practice in the Rules of Court 2012 shall apply mutatis mutandis. However, in this case, it is specifically mentioned in Rule 6 in respect of the service of the notice of appeal. Thereby, these Rules of Court of Appeal shall be applicable instead of the Rules of Court 2012.
Shall prevail, you saying?
You're saying by Rule 6, anybody can do the service, is it? Anybody can do the service. Can be court or interested party or third party or any person affected. Is that you're saying? Rule 6 has that implication? It's very wide. Anybody can serve the notice of appeal.
My lord, we believe that the service can be done by anyone so long as the respondent is served with a copy and get the necessary sufficient notice of the appeal.
Yeah. That's all.
My lord, may I continue to submit the following grounds for the PO?
What ground? Your position now is that the service done by court, it amounts to good service.
Yes,
so
my lord.
The PO doesn't stand.
Yes, my lord.
And section 1(2) or even section 1(2) doesn't apply here.
Yeah, and section 102 doesn't apply.
But you agree section 1(2) retains the dichotomy of nullity and irregularity of action, right?
We maintain that there is no non-compliance of rule in this matter, my lord. Yeah. And another ground is that the respondent has failed to show that they have suffered substantial miscarriage of justice as required under Rule 3A in respect of the issue of PO.
That is the reason why you did not file any application motion for extension of time, because you take the position that there was no non-compliant. Is that?
Yes, my lord.
Okay. Yeah. What else do you want to say? What else? Any further points?
We have another court of appeal case on preliminary objection on the issue of technicality, which exactly happened to our current case now, whereby it was held that after the notice of appeal was filed, such procedural technical objection shall not be allowed to obstruct the process of giving justice to the deserving by going into the substantive issues to the matter before the court. Based on the grounds submitted above, it is respectfully submitted that the respondent was served with the copy of the first notice of appeal on 26 June 2018 via email, which is well within the time limited. Failure of the respondent to prove any substantial miscarriage of justice suffered by them is fatal to the respondent's PO application. Therefore, we would like to pray that the PO application be dismissed with cause to the appellant.
Sorry. Why did you subsequently serve a physical copy of the notice of appeal to the respondent subsequently?
The second. Yeah,
why did you do that?
Okay. The service of the second of notice of appeal was a sealed copy of the notice of appeal. If you can read in the service letter itself, we further enclose the index record of appeal for the respondent's further action in marking the necessary record of appeal.
No, about you serve on the respondent the notice of appeal. You mean the sealed notice of appeal?
Yes,
11 days of the day.
Yes, my lord, that's a sealed copy of the notice of appeal, which was forwarded by us to the respondent solicitor.
Yeah. Yeah, thank you. Mr. Mark?
Yes, my lord. Short reply. Now, a question to ponder.
Does Rule 3A apply, is it not?
Sorry, my lord?
Does Rule 3A of Rules of Court of Appeal apply?
Yes, on that issue, my lord, the technical non-compliance only refers to those non-compliance which are not mandatory. In this matter, Rule 6 is mandatory. In breach of mandatory rules, the appeal is considered as incompetent. Now, I wish to share with your lordships and your ladyship one federal court case. One moment, my lord. Okay. This one, my lord. In the case of the federal court case of the Duli Yang Amat Mulia Tunku Ibrahim Ismail Ibn Sultan Iskandar Al-Hajj against Datuk Captain Hamzah Muhammad Noor and another appeal 20094 CLJ 329. Now, whereby the court held, in the context of the rules of the court of the High Court, the phrase technical non-compliance refers to non-compliance with a rule which is not fundamental or mandatory in nature. It follows that Order 1A cannot be invoked to cure failure to comply with the prerequisite of Order 6, Rule 72A. Now, the service under Rule 6 is also mandatory, and I wish to share one case law as well. in the Court of Appeal case of Chen Kong Theoris and Berhad against Lee Gyok T and another 20188 CLJ 10, where Ladyship Marilyn held the one in the one highlighted that Rule 6 of the rules of the Court of Appeal is mandatory in its terms, the failure of which renders the appeal incompetent. Therefore, the non-compliance of the appellant in not serving the notice of appeal cannot be cured under Rule 102.
Okay, Mr. Mark. I think that is not disputed by Connie. Connie is saying Rule 6, Rule 6 does not provide the way how and who is supposed to serve the notice of appeal. Anybody can do it.
Exactly.
Connie is saying that there is no issue of non-compliance.
With due respect, my lord, to the council, now I've cited Rule 30 of the Rules of Court of Appeal, which in relation to service, the rules of court shall apply mutatis mutandis. In the rules of court, in the issue of appeal, it is specifically mentioned under Order 55, Rule 3.4, that the notice of appeal must be served by the appellant. It cannot be some other people not related to the proceeding to effect service. Otherwise, there will be chaos in the rules and procedure. This cannot be allowed. The burden must be cast on the appellant to ensure that the notice of appeal be served within time.
So we take that point. Now if we agree with that point, now the second issue arises here. I.e., now the issue of mandatory or non-mandatory will come into play, or not? If Rule 6 is mandatory, you're saying by this authority, by the Federal Court Authority and the Court of Authority, then this issue of Rule 3A preliminary objection doesn't apply. The appeal is just incompetent. The court has no jurisdiction to hear. Is that your stand?
Indeed, the appellant in this matter, they did not comply with the rules. So, definitely their appeal is not brought forward before this honorable court, because the service was effected after the time limited, my lord.
Okay.
Lastly, this one very particular point, my lord, that the administrative action of the court again cannot be mistaken as to be service on behalf of the appellant. The appellant must themselves serve the notice of appeal as required by them under this Rule 6, together with Order 55. The notices that they have submitted is a very general notice. It's a very general provision whereby any notice, it does not mention specifically the matter that the parties to effect the service. But in Order 55, it is very clear the appellant must ensure service of the notice of appeal. This is our stand, my lord. And indeed, if they have truly complied, there is no need for them to send a second reminder, which is not even required under the law.
Okay.
That is all, my lord.
That about all, Mr. Mark?
That is all, my lord. My lady.
Thank you. So, we will adjourn for a short while for deliberation. Thank you.
Much obliged, lordship, ladyship.
May it please my lords and my lady, case is recalled.
We thank. Okay.
Party says before, yeah?
Okay. We thank Council for their submissions, and this is our unanimous decision. It is our reading of the law that it is incumbent on the appellant to serve the notice of appeal within the time limited by the law. In the instant case, there was no service of the notice of appeal within the limited time by the appellant on the respondent. We note that there is no application for extension or abridgment of time filed by the appellant. And we further note that the Administrative Act of the interpreter in sending a carbon copy of the notice of appeal to the respondent does not amount in law to service within the meaning of Rule 6 of the Rules of Court of Appeal. We therefore uphold the preliminary objection by the respondent. And following that, we strike out the appeal with cause. We invite parties to address us on cause. Do you want cause, Mr. Mark?
Definitely, Manap.
There is no cause.
Definitely, we require cause because services has been rendered. But I believe the amount of 10,000 is reasonable.
10,000, is it?
Yes, Manap.
Yeah. Connie?
We request the cost to be 2,000.
How much?
2,000.
How much? 2,000.
2,000, yes, my lord.
Yeah. Itu. Lebih. Yeah. Okay. We give cost of 5,000 subject to helicopter.
Much obliged, Your Ladyship.
Your lordship.
Thank you. Yeah.
Right.